Welcome to the Global Pulse, a short video series where our experts break down a trending topic in international business and why it matters to you.
The legal difficulties faced by X, formerly known as Twitter, in the country of Brazil send strong signals to American multinationals operating online speech platforms such as X. The reason for this is because of the changes that have occurred, not just in Brazil, but around the world regarding online regulation of speech, particularly speech that some countries determine under their new domestic laws to be hate speech, anti democratic speech, or some other form of speech that is not acceptable in that particular host jurisdiction. In the case of Brazil, X has found themselves in a difficult situation primarily because, as an American multinational corporation, they are operating under principles of American law, particularly American law as it relates to regulation of speech, the content of speech, and its dissemination on online platforms. From this perspective, this is in great contrast to what happens in Brazil, particularly with the changes that have occurred under Brazilian law. In Brazilian law, leading up to the most recent presidential election, Brazil recently changed their laws to make it so that online speech that specifically targets anti democratic speech or hate speech may be subject to takedown orders and regulation. In Brazil, Brazil has empowered a single justice of their Supreme Court to make determinations unilaterally, as was the case with X, as to what form of speech content is acceptable on these platforms. As a result, X received multiple takedown orders in the hundreds to terminate accounts that were operating on X that the Brazilian justice determined were violative of Brazilian law's new order with regard to online speech regulation. X, coming from American principles where speech is more permissive and protected, decided not to comply with these takedown orders. As a result, X faced multiple fines that ultimately culminated in a termination of operations of X in this country of Brazil. To draw a contrast here, and why American multinationals need to be very careful of how they're operating in host countries, aside from the general understanding that they cannot take American laws for granted as if they will operate in the same manner in a host jurisdiction, in particular context with online speech platforms such as X, this is inherently unique because of the very unique nature itself of First Amendment law in the United States of America. Further, in the United States, aside from broad protections provided for speech through the First Amendment of the Constitution, we also have unique laws, particularly in Communications Decency Act, Section 230, also known as CDA 230, which grants broad immunities to online platforms such as X for speech content that individuals disseminate on that platform. CDA 230 was also recently reaffirmed to some extent by two recent US Supreme Court decisions, which bolstered this kind of perception that American multinationals that run these online platforms have as to the immunities that they would be granted, but under American law rather than foreign jurisdictional law. That leads to some of these complications that we see emerging, such as what we have with X. X perhaps operating with the understanding and the privileges and freedoms that they have under CDA 230 in American domestic law that does not translate well into other jurisdictions, particularly as they change their legal landscape to combat what they view as maybe anti democratic and hate speech. It's not going to be the same degree of liberty that these American multinationals enjoy back home in the United States of America.